Hello friends, in the series on the income tax cases, today we will discuss a very important case on protective assessment and revision under section 263. There is no concept in the Income Tax Act about the protective assessment, but over a period of time, the protective assessments which have been done by the income tax authorities have gained judicial recognition over a period of time. The question arises, what is protective assessment and whether the protective assessment will prevail when some substantive addition has been finalized or confirmed in the case of other assessees. This issue has been taken up by Jaipur I.T.A SMC bench in the case of Dinesh, Kumar, Chaurasia versus Assistant Commissioner of Income Tax, and this case is reported in 123 I.T.A Tribunal at page number 702. The date of the judgment is 30th December 2024. First of all, what is protective assessment? When the income tax authority is not sure that in whose hands the income is to be assessed, whether in the hands of A or B, or whether in both the hands the income is to be assessed, when the assessing officer is not sure about this thing, then the assessing officer goes for protective assessment in the case of the assessee. And when over a period of time, in the case of other assessee, the substantive addition is established or confirmed by the higher authorities, then the protective assessment should not prevail in the case of the assessee where the protective assessment has been done. This is the general concept. Basically, the protective assessment is done just to safeguard the interest of the revenue, that if some protective assessment is not done and if the assessment is not finalized in the hands of the other assessee, then the department will be the loser, only because it was not shown to the department that in whose hands the assessment is to be done. This is the overall concept of protective assessment. In the present case, there was a survey on the assessee, and in that survey it was found that the assessee has sold some lands to an individual. When the assessment of that individual was being done, it was done on the substantive basis, and the assessment in the case of the assessee was done on the basis of protective assessment. The assessee, after some time, received a notice from the Principal Commissioner of Income Tax for revising the order which was passed under section 143 subsection 147, in which the protective assessment was done, that the protective assessment should not have been done, should be done as a substantive addition. The assessee submission was that the other individual in whose hands the substantive addition has been done has been confirmed by the Commissioner of Income Tax Appeals. So now it is established that the substantive addition is to be made into the hands of the other assessee. So in my hands the protective assessment should go, and hence there is no question of revision also. But the Commissioner of Income Tax didn't consider the submissions of the assessee, and the assessee filed the appeal before the tribunal. When the tribunal heard the matter, the tribunal said that in the case of the assessee, the protective assessment was done in the relevant year also and in the previous year also. So the revenue was sure that in the case of the assessee, the protective assessment is to be done. But since after the issue of notice under section 263, but before the order under section 263, the assessee has brought to the knowledge of the learned Principal Commissioner of Income Tax that for the amount for which the protective assessment is done has been now finalized as substantive addition in the hands of the other individual. So in that case, the order for the protective assessment does not prevail, and if the order for the protective assessment does not prevail, hence the section 263 proceeding should not prevail. So the tribunal quashed the notice and the order under section 263 on the ground that once it is finalized that the substantive addition is there in the hands of other assessee or the other individual, so in the present case the protective assessment should not prevail and consequently the revision proceedings. At the end of this video, once again I am repeating the name of the case. The name of the case is Dinesh Kumar Chaurasia versus Assistant Commissioner of Income Tax, and this case is reported in 123 I.T.A. Tribunal at page number 702. The matter has been decided by Jaipur I.T.A. Assessee bench on 30th December 2024. Thank you, friends.